Hi everyone, and welcome to another interesting episode of Aging Gracefully. Today's topic is about a legal will and testament, and it's an interesting topic. It brings out a lot of different feelings among all of us. For some of us, death is a relief. For some of us, it's a celebration. For some of us, it's an event. But for all of us, we have a lot of feelings attached to it. It's a huge emotion bank. So to help us navigate through this emotion bank, we have two experts, I would say, on our panel today. Mr. Robinson, who will basically be walking us through and hand-holding us through navigating this pretty difficult process. And Father Juventius Andrade, who is actually going to be our spiritual advisor to help us look at relationships and all the other things that come along with this. We also have a lovely audience who's going to actively participate in what we want to talk about today. So I'm going to hand it over to Father Jui.
Well, thank you for that introduction and that welcome. And I think we need to also know who our wonderful hostess is, Sharmila Martis Arora. Now, she is a woman of many parts and many graces. She began as an engineer, entered the banking field into advertisements, startup, and now she's got her own service-oriented organization which touches the lives of so many people, not only of privilege, but particularly because of the privilege to those who are underprivileged, the social dimension. And so you bring a lot of that experience also into this conversation. And we are happy to welcome you here because I seem to be the thread that has been through all these episodes of Aging Gracefully, a talk show for evergreens. And so it is that context I want to place this program, because we've always had on our panel someone who's professional with the education and the tremendous experience. But until now, they've always been doctors. So, Mr. Robinson, you're the first non-doctor, I would put it positively, the first lawyer that we have professional who comes with tremendous experience on the state level, on the level of the local level, plus on the very human and personal level. So what we are, in the past, we've done episodes 13 to 15, which have dealt with living will, conversations about the final journey. Today we're going to talk about the legal will, and we'll take a look at that distinction a little more later down in the program. So, but I just want to say that this episode that we are doing today could be addressed to a number of our viewers, but particularly to those who are in the process of making a will, who are tasked in doing a will. It's also addressed to who would possibly be the beneficiaries. And how is this process made? How do we help urge them toward the process, but also respect the wishes of the one who's going to make the will? Because while the will might be a legal document, it's also got to do with relationships. And so as we navigate, as she put it so beautifully, through the emotional dimensions of what might be a formal legal document is not done in the abstract, in the vacuum. And so therefore, I would hope that this, our conversation today, would help. Now, as always, we come with disclaimers, because while we do have tremendous persons of experience and education and a lot of looking at the reality of this life, this is a talk show. It's enabling conversation for people who need to act on this. On the basis of what is being shared today, it's for you to take that conversation forward, because sometimes this is not a conversation easy to have. And hopefully through this interaction, it will be made a little easier, or as she used that lovely word, handheld in making that process. And so it is in this context I want to place this episode against the background of all the other episodes we've had so far of Aging Gracefully, a talk show for evergreens. On that note, let me hand it back to you, Sharmila.
Thank you. So let's start with a life experience. I remember this memory very vividly. I was on a plane with my grandmother. She was wearing a very pretty sari. And I looked at her, I was on her lap, and I started feeling the sari. And I said, the sari is very pretty. And you're looking very pretty in it. I really like this sari. And she said, okay, don't worry. When I die, you can have this sari. And I said, when will you die? So, as a 4-year-old, our concept of death is that simple. It's an event. It's gives you things and assets that you would otherwise not got. But as you grow up, it becomes a little more, complex. For some, a bit morbid. So today's conversation, I want to keep it deep, but I want to keep it light. Okay, and that's why I want to start with a couple of questions for our lovely audience today. How many of you all look at death as a celebration? Can I see a show of hands, please? Is death a celebration? 1, 2, 3, 4. Okay. For how many of you all, it's something you dread of yourself or a family member? Also, maybe? Yeah, I dread death of a family member. Yeah. Okay. And the last question is, do we all agree that death is an event? Do we all agree that death is inevitable? So, like any event that's going to happen, right? We decide to go on a journey, we pack our little, packets of food. Like, have we prepared for death, right? And if I have to give you a checklist and mark you on a score of 100, would you give yourself 100 on 100? How many of you all would give yourself 100 on 100? Mr. Robinson and maybe one more lawyer, right? So I'll ask a very straight question because this question is directly related to the success of today's talk show. How many of you all have made your legal will? Okay, 1, 2, 3, 4, 5. How many of you all have not made a legal will yet? 1, 2, 3, Tina? 4. Okay. So we have a pretty good 50-50. Right? So we will, let's have this conversation and see whether the 50-50 stays 50-50 or it moves, because that will tell us whether we're doing a good job. I wanted to start with, I am here because of Jui, and Mr. Robinson, I hope, is here because of me.
Yeah.
I am not here because I'm an engineer or anything else I do. I'm here because I have just gone through a pretty traumatic experience of making my own legal will. And I had decided that by the end of last March, I'm going to have a legal will done and dusted as part of my responsible bucket list as a wife, as a, parent. And I was very shocked because after setting things in motion, I had listened to Mr. Robinson at a talk and I was convinced he was the guy to do it. I was also a little worried because, being a senior, they also have very strong standards of how you should interact on these things. But I must say that Mr. Robinson got into the process. He would call me, and what I thought was actually an 8-week process, I actually delayed for almost 18 to 2 years. 18 months to 2 years, correct? Right? And I was surprised at myself because normally when I decide to do something, I do it quickly because I like to move on to other things. And it got me thinking, saying, why am I not getting onto this? And it brought me to a lot of questions about, actually I don't want to do this. I'm facing my own, demise, and it's not pleasant. And, and so many emotions came up. I had to deal with my biases in terms of, do I prefer a person more than the other? Do I take care of my siblings? Do I take care of my children? All these questions start coming up and you have to take a hard call. And it's very difficult to take a hard call. So I had started the process thinking I'll be responsible and I will help my next generations to have less issues because they will have a legal will. But there was a point when Mr. Robinson called me and he said, if you don't mind, I'd like to take you off my list of potential clients because you've made no progress. You have not sent me any details and I can't keep calling you up. And that's when I said, no, this is not fair. I have to get into the process, gritted my teeth. There are a lot of things you have to get into place, list your assets, list your jewelry. There's a lot, right? But I'm so happy. I actually managed to get it done by my own deadline, but I'd given myself a good 2 years. So I want to talk about some of those issues, Mr. Robinson. And I think the first issue is...
Before that, I want to intervene. She also asked me at one stage, have you planned for a successor for you? Really, that I was thinking, why she is asking me that I need a successor after me. I appointed another person. But all this making wills is confidential. I can't share with others.
So the reason I
Okay,
asked him that question is he did such a wonderful job. I was very keen that if I die, he should actually be someone who executes my will, right? But God giving, I hope that that is the case. But I said, given your age, do you want to make sure that we have a second in command? Because if you're not around, I would want someone equally capable, right? So let's start with the first question, which I think is, so Mr. Robinson, can you explain to us what is a will?
A will is a legal declaration made by a person for the distribution of that person's assets and properties, which takes place after his demise. That's a legal will.
And what are the benefits of making a legal will?
Let me share with you examples because I have been doing wills since a long time. I made my first will for a widow in the year 1976. Yeah, what's the benefits of making a will? Let me share with you 3 incidents that have come in my life. First, I call it Dubai will. A Christian from Mangalore worked in Dubai, hard work, amassed wealth, and invested it in properties, immovable properties in Mangalore, and in landed properties in a village close to Mangalore. He had only one daughter, and when he retired, he came back to Mangalore, and at the same time, he got his daughter a job in the Gulf. Everything was going on well. COVID time, the couple, the parents, went to visit their daughter. It so happened, both of them died on the same day within a gap of 15 minutes. He had not made a will. Daughter was a spinster working in a bank in Dubai. She wanted to withdraw some money of her father. Bank said, you should have a succession certificate. Daughter didn't have any idea where the documents were, where the assets of her parents were. Of course, they had a locker in Bangalore. She got the name of that bank. She contacted. Initially, they tried to give her some help, but later on, they disconnected. Then she approached the LIC agent who had a policy on the life of her father. After some time, he disconnected. Father had allowed his close relatives to occupy the premises in Bangalore and Mangalore. Nobody was responding. And she was contacting me to get a succession certificate. To file an application for succession certificate, we require the person or a power of attorney holder. She can't come leaving her job there and to file cases in the court. Mr. Sauraraju, as an advocate, experienced person, he knows the difficulties. She couldn't get a power of attorney holder. We struggled for about 3-4 months, then we stopped. That's one case. Recently, last week, a lady approached me. Young, 41 years, from north, they were working here. Her husband died in January at an young age, maybe around 44, of cancer, leaving his wife and 2 minor children, 11 and 10 years old. They had borrowed a loan from SBI Bank, housing loan. After death, wife repaid the entire loan, balance amount, and went to the bank to collect the title deeds, which had been given to the interest of the bank as security. After collecting all these dues, they gave a list of 7 documents to the widow, asking her, you get these documents. One of them is a legal aid certificate from the government. But the government has directed, Kannada government has directed revenue officers not to issue any legal aid certificate to public except for the relations of the government servants. Public should obtain a succession certificate of the court. Here is a widow at young age of 41, 2 children minor, she has to take care of them, manage the household, and has to work in the night as a digital designer. Where she has got the time? She doesn't know Kannada. And she can't get one of the important documents. And that document is not required for this, legal aid certificate. She has repaid the entire amount. Legal aid certificate is issued for a different purpose. Here she has to get the documents which she had submitted to the SBI along with her husband to obtain a housing loan. And in order to return this certificate, they want, government doesn't issue a legal aid certificate now, section certificate. Sir, section certificate is issued to collect certain debts or monies owed to the deceased person. Here nothing is involved, only return of documents. If that person had made a will, this would not have happened.
Thank you.
Thank you, Mr. Robinson, for giving two very striking examples about what happens if you don't make a will. Now, it's interesting why people would hesitate to make a will. They think death will come, but we don't know when it will come, and perhaps in the distant future, but one must always be prepared for eventualities. But it's really dealing with the deeper issue is, how do we see death? How do we face the fears of death? And these are questions, as you so beautifully explained when you were going through, like, things you never thought about that put it in context. So thank you for putting some flesh to her question.
So that brings us to the next question. What's the right age to make a will? I just heard someone saying, I'm too young to make a will.
Any person who wishes to make a will must have attained the age of 18 years. But to make a will, ideal age according to me is 35 years. He must have, after 35 years, he must have started working and accumulated some wealth, some job. If he's married, it's good. That's the ideal age, because one can change a will any number of times as it progresses. And I always suggest my clients, after a gap of 5 years, you review the will. So 35 years, started working, accumulated some wealth, then married. Of course, one person can make a will before his marriage. But once he marries, that earlier will becomes void. He has to make a fresh will.
Why does it become void? Because you've made a will. Out of respect for the equality and dignity, I understand that now a new reality has come into the picture. But what are the legal grounds? That's what I'm more concerned with.
Father, it's very simple. The law is like that. Law has provided provision that if a will is made when a person is not married, if once he marries, then the will will become void and he will have to make a fresh will. Possibly the Parliament or that time, we are governed by Indian Succession Act of 1925, which was enacted by the British time. They thought the security of the woman, maybe.
I'm fully in agreement because that really defends the rights of women. But the reason I asked this question was so that others who are listening to the program will understand the importance that with marriage, there's a reordering of relationships, because sometimes he could just go on with his own families and the in-laws could just ignore the wife. So I'm glad you brought this point out into the open. And it was that intention I really asked the larger question.
So when we went through the will process, you said it was quite simple. So what is required to start actually having a legal will? Like the simplest things required or the most easy path to actually get a will done?
Yeah, you have to provide the material, the contents about your assets. First, your details, your family background, some blank. Then whatever the assets you have, then indicate to whom those assets have to go, how they have to be distributed. Because the will is yours, not ours. We only help you to put it into a shape and legal shape, that's all. We as advisors, consultants, we don't interfere with your intentions. We just, and if there is something wrong, we suggest you, this is not wrong, this is. But distribution of the assets, to whom, what should go in what, that's all yours. We don't suggest anything, which I don't interfere. That's your wish.
But it was interesting when we went through the process, you actually had some very interesting suggestions. Like, I was under the impression that if I'm in a joint property ownership, it automatically means that when the other person passes, I get the property. But you actually came back and said, no, it has to go through the same process, whether it is joint or otherwise. Is that correct?
See, joint property, there is another person who owns a certain share in that property. You are not the full owner of that property. You can't make a will in respect of that share of another person. No, you can't.
Yeah. So there, I think the more thing was that I had.
Once again,
yeah.
let me share with you an incident happened in Chikmagalur district. There was a family, a number of brothers. The family property was there. The eldest brother's son, he made a will, eldest brother made a will, giving all the properties to his son, nothing to other brothers or children of other brothers. Then there was a fight. Court cases. They spent nearly 20-25 years in the court fighting for this property. He made a will in respect of family property. Certain portion didn't belong to him at all. The other brothers said, and ultimately they succeeded. Waste of time. So one can make a will only in respect of his properties, not of others. For example, if you have a bank account, joint bank account, that bank account operated by you as well as your husband, both of us that you can't take his share and make a will and give his share to somebody according to your wishes. For that example, a property owned jointly by husband and wife. One person can't make a will in respect of the whole property, only in respect of that person's share.
So an interesting one that came out on bank accounts. If I have a joint bank account and the other person passes away, will the bank freeze those accounts until they get some documents, or am I allowed to continue working the account in the absence of a living joint nominee?
Interesting question. I want you to repeat it.
Okay.
I tell you why.
Yeah.
Go slow.
So we are joint account holders of an account, and the person whom I'm a joint account holder with passes away. In that event, does the bank stop dispersing funds to me because they are waiting for the other person's permission, or do I continue to use the joint bank account like the person is alive?
Yeah, when you make a joint account, there you have to make a condition there that normally done, which you missed to mention here. You definitely have done. Their operation of the bank account either are survivor. So if a person passed away, the other joint account holder can continue that account.
So the bank will ask for this.
Yeah,
The bank asks for
already
this?
it is there.
It is there. Okay.
It is already there. So say I myself and my wife have joint accounts. All our accounts are joint. So if I am not there, if I pass away, my wife can operate that joint account.
And the bank won't give you any trouble?
No, there will be no trouble.
Okay.
She is authorized.
She is authorized.
She can operate that one, that joint account. But remember, FDRs, fixed receipts, fixed deposit receipts, FDRs, if they are joint, if I die prematurely before the FDR is over, during my lifetime we can close it, both of us. If I die, my wife cannot collect the money. She has to wait until the FDR is matures. Till then she has to wait. Otherwise, she has to get the consent of all the legal heirs. Then only the bank will release the funds.
This is a very interesting point, because I know seniors, and I never understood being a banker, who would always keep renewing their FDs only for 365 or 366 days. And I was like, why would you do that? You know, you have a much better rate for the 2 or 3 years. But now I understand that by actually renewing it by only a year, it means that the other person who has a joint ownership of that can access the fund in 366 days. If they put it into a 3-year thing, I can only access the funds after 1,000 days, right? So thank you for, I remember this being something that you told me during my bill, and now I know why there is a 1-year option.
This applies only to fixed deposit receipts, term deposits. But for bank or SB accounts and all, Yeah, the surveyor can operate it.
Great. So that brings me to my next question. What is the role of a nominee? Or when I nominate someone, what does it really mean?
Yes. Banks insist upon nomination for every instrument, maybe savings bank account, fixed deposit account, provident fund, etc. nomination. But nominee will not be the owner of the money. He is only the receiver. And when the banks or financial institutions hand it over to the nominee, they are safe, their job is over. It is the responsibility of the nominee to distribute that amount among the legal heirs of the deceased person, or legal heirs of the person to whom that money is belonged. So, if a family comprises of husband, wife, and a daughter, just for example, husband makes nomination in favor of wife. He doesn't make a will. He expires. Wife will receive the amount, the entire amount covered by the nomination, but she cannot use that amount. That entire amount is not hers. It is her duty to distribute that amount among the legal heirs. In this case, daughter is there. According to Indian Succession Act, when the will is not made, wife will be entitled to only 1/3 of the share. Children will get 2/3 of the share. That's why a will is essential. If that person wants to safeguard the future and safety of his wife when he is no more.
Thank you. So, as a wife, what if he has made a will that says the entire amount is going to my wife, who's also a nominee?
Will supersedes and overrides nomination.
Got it. Okay. So that. Now let's bring Juvie into this conversation. So Juvie, I noticed when we asked whether people had made a will, you didn't raise your hand. You want to tell us why?
Well, that's because I belong to a religious congregation. Technically, because I take the vow of poverty, I do not have assets in my personal name. Though we make an informal will within the congregation of priests and brothers that I belong to, but it does not have the weight of a legal will. It is different from a priest who belongs to a diocese. That's the reason. But I do have to make an internal will which will respect my wishes of whatever my books or whatever belongs to at the moment of my death.
Okay, so there are many terms which sound quite scary, right? There's executor, testator, testatrix. So do you want to explain to us what these
No, these terms are not scary. These are person who are going to help the execution of the will. Now, for every will, there must be four persons. The first is the person who makes the will. If he's a male, we call him as a testator. If he's a female, we call it a testatrix. Then the will maker, the testator, has to constitute a person, appoint a person to give effect to the will. He is called the executor of the will, not executor of the other person. No, executor of the will. It is his duty to administer the will, to give effect to the wishes and desires of the person who has made the will. And there are two other persons. They are called attesting witnesses. Attesting witnesses must be present when the will maker signs the will. They must see him sign the will, and the will maker, that the testator, should also be present when the attesting witnesses attest the will. So these four persons should be there.
So most of the time, the testator is the lawyer?
No, testator is the person who makes the will.
Who makes the will? Okay.
Male, male, female,
is the person making the will. Okay.
Yeah.
And the two attesting witnesses, and you have executor doesn't need to be there.
Executor need not be there.
Okay.
the testator should take the prior consent of the executor, prior consent, because he must have time to give effect to the will. You have properties in Bangalore. If you appoint an executor for a will who works abroad in America or Canada, he must have time to come here and give effect.
Absolutely.
And he will find it difficult.
Correct. Correct. So you have to be practical about
You
it.
must be practical. You have to
Okay.
say. And when you appoint an executor, you first take his consent and see that he has got certain responsibility, because property vests in him when you die. It is a responsibility to distribute according to will. A beneficiary can also be an executor.
Got it. So just come back to this, right? So once the will is made and the person passes away, what's the process for the will to, what happens next? For the will to come into effect, what happens next?
Earlier, probate was there. Christian will needed probate. But recently, government has amended the law. Section 213 of the Indian section has been amended. Now, Christian will need not be probated.
I don't understand probate. What is probate?
Probate means it's an order of the court
Okay.
approving the will with the seal of the will and authorizing the executor. The executor files application of probate to the court. Court issues a public notice, then issues its order approving this will. For that order, issues an order authorizing the executor to execute the will, to implement the will. That's called the probate.
Could I ask a question? So, what's the difference between registering the will and probating the will? Are they synonyms or do they mean different things?
Both are different. Register will means you register the will in the sub-registrar's office. You sign the will in sub-register, witnesses have to go there. They also attest the will date. Probate is, this is during the lifetime. Register will during the lifetime of the will maker. But if the will can be registered even after his death, there is a certain period of time is there within that. It can be registered. But probate, after the demise of the person who has made the will, probate order will be issued by the court on the application of the executor. If the executor of the will is not there, not mentioned, then one of the benefits, legacies, beneficiaries can approach the court for appointing an executor.
So without the legal probate, now they're saying they've taken that out. What happens to the will next? How does it progress?
You have made a will. Let me take, for example, you have made a will. You have appointed an executor. After you are passing away, the executor, then he has to give effect to the will. He need not obtain an order from the court, probate order from the court. Then it is a responsibility to distribute the assets as per the
Will.
as mentioned in the will.
Okay. And when they're doing this distribution, right, even though there's a will, people are asked to give no objection certificate. Why is that?
I have not heard of that one.
Okay. Sometimes when there's a property that's being
no
of the siblings.
No object certificate are normally insisted upon by courts, by government officers and all, not by the executor.
Yeah.
When the executor distributes the property, he may request an acceptance of letter that he has provided, acknowledgement. But
No, I'm talking more about, say, for instance, there's a property involved.
Yeah.
It may be belonging to the deceased and it's been gifted or it's been given to one of the heirs. So for us to register the property in that heir's name, is it required that the other siblings provide a no objection certificate?
Yeah, see the complex question about these things, gift here involved, but I'll tell you, no object certificate I came across. A person died, he made a will, distributed the properties among his people. That time, registering Khata by the municipality, they insist no objection certificate from others, only for the transfer of Khata.
Got it. So transfer of Khata still requires all your
They
siblings or
insist.
whoever's
They
legal heirs to.
see, death certificate you have to take, that he is no more. Then will you produce. Then they ask for a family tree. Then for their safety they ask for an object certificate to transfer the Khata. But we must remember that Khata is not the legal title. It's only to make the payment of tax, property tax, that's all. Legal title, original mother deed, original acquisition, deed relating to the acquisition of property by the testator, then the will. They are the legal titles.
So that's an interesting one, right? So we are saying that there is, when you talked about the Hindu law, you said 1/3 to the wife.
No. Christian.
Sorry. Okay. So Christian
Indian
law is
sexuality.
1/3 to the wife and 2/3 to the children.
Yeah.
And Hindu law is also the same?
That I am not.
You don't know. Okay. So we should be involved with only the Christian law. Okay, good.
That's different. Hindu Section Act is different.
Mr. Robinson D'Souza, I have a situation. My father died without a will, and the property we had was registered in my mother's name. Subsequently, my mother made a will, and she had willed it equally amongst all of us siblings. After her death, my brother and me as executors ensured that the property was registered in all our names. How do we go ahead to ensure that all of them get their properties if it is to be sold equally?
Was the property belong to your father? You said there was a property, my father expired, the property had been registered in the mother's name. Was it purchased originally in your mother's name?
Yes.
Originally in your mother's name. Father had no right at all in that property, since property was in your mother's name. Mother made a will, distributed the property among your siblings. Then after death of your mother, the will comes into effect. All the siblings become its joint owners. Now it's an immovable property. In order to divide it equally, it has to be sold. There is no other way. And the proceeds received in the share, that are to be distributed equally among the number of children.
Okay.
There is no other way.
So the executors have no role in this once it is registered in the siblings' names.
Executors have role only in executing, implementing, give effect to the will. Once that has been done, the role of the executor ceases.
Okay.
Then each person, each successor will become the owner in respect of his share.
Thank you, Mr. Robinson.
So Father Juvi, you want to take us through a little bit about your thoughts on equality and equity?
Okay, so now we are dealing with the beneficiaries. And I want to make a distinction between equal and equitable. I don't refer to equity to you as a banker, but I speak about equitable as being fair and just in the distribution for the beneficiary. For example, you might have 3 or 5 children. When you say an equal share, in other words, everyone gets proportionately the same. What is equitable? Equitable is wanting to be fair and just depending on the needs and the circumstances, because each of the children might be different. If there is one child who is differently abled or handicapped for whatever reason, one would hope that in the process of equity, this one will get more. Or again, in the situation where one child has lovingly put his or her life on hold, accompanying the parents for the last few years of their life, not taking a vacation, in other words, always being present. The others do care to the extent they can because of their personal responsibilities. It's not a judgment. They might even parachute in when there's a case of emergency. But that one person has been there all the time. And so, in the process of equity, they will get, at least by this sense, a little more. Now, the reasoning is important, and the testator, the one who's writing the will, might indicate, for all that has been happened, I would want to express my gratitude. And the rest of the siblings might say, that's fine. But it could be some will ask and clamor for something that is equal and not equitable, because they feel They are not getting the equal fruits of it. And sometimes, sadly, this is a tragedy that's played out in too many families. Some of them who scarcely have visited their parents when they're alive, after the death, they will be visiting the lawyer in the court far more frequently than the parent is alive. And so this creates such a climate of mistrust and suspicion. Sometimes the parents feel like on the basis, I have to give equal share because what will society think? That I've favored one over the other. Now, it's interestingly, one must be just. But being equal is not always equal to being just. There are different needs, there are different struggles. Sometimes money is put in a trust, particularly to attend to that, child who has not have the ability or the privileges that others have. Because when it comes into this, it can be very painful. And most often, those who already are quite comfortable will make a greater clamor for that. And those who have been struggling feel that they're being sidelined in the whole process. So while we are talking the legal language of wills, which is important because we need to be absolutely clear, the basis of that is relationships. The relationship between the parent and the children, the relationship between the children among themselves. If the relationships are positive, healthy, and good, there's a lot of understanding that takes place. But if there is a silent Cold War happening, misunderstanding, then when the time comes for the reading of the will or the distribution or the beneficiaries, then all these come to the surface. What might appear as a cry for justice, for equality, really sometimes is masquerading a jealousy, envy, anger, and hostility. So these are the very persons who grew up in the same home and family, but now the whole dynamics is so poisoned. And the reason I mention this is this happens all too frequently in many families, even Christian families.
So I'd like to conclude this as the first part of the 3-part series of Legal Will. I hope you guys enjoyed the first part. As you can see, there's a lot of discussion and there's more to go. I do hope that you will be able to watch the 2nd and 3rd episodes as well. And my sincere plea to you is that this is an important topic. That's why we have picked it up. Do share with your family and friends. Like and subscribe. Please put in a lot of the questions in the comments. We love reading them. They will also help us answer a lot more questions that you want in the other episodes. So looking forward to the next episode with you guys soon.
I like to understand this or respond to this on 2 levels, and then I'll pass it on to our profession.
What the children get under the will of their parents is a gift for them. The parents work hard, save all these things, then when they are no more, they make arrangement so that the children will succeed to the assets and properties which they have accumulated for the sake of the children.
The responsibility for an executor sounds quite grave. An executor has to do a lot more work than just be a legal. He may or may not be a legal heir, but it's a lot of work. So what are the qualities you look for in an executor? Other than the fact that them being in the same city helps, what else do you look for when you name an executor?
The father and the mother are flying together. They got a 10 or 15-year-old child. They have made maybe a kind of a mutual will, but there is a plane crash. Now the child is 15 years old. What about, because there is no legal document indicating a child or maybe 2-3 children who are minors in that case.
When a will is made, the person doesn't lose his right on the property.